This week is just a look at some basic legal principles related to our legal system here in the U.S. We're going to define some key terms that we're going to be using all semester long. I know everyone has a little bit of a different background when it comes to the law and civics. Some of you may have taken a law class here or at another college. Some of you may have not interacted with this content since high school in a civics class. That's fine. That's why we take this first week to really just lay the foundation, get some of these keywords out there into your brain, into your system, so that when we do actually start applying some of the more technical content, looking at specific legal issues, that we're all on the same page. So that's the plan this week. We're going to look at some of these key legal terms. We're also going to talk about the various court systems and then look at the trial process and the various steps within the trial process. Okay, so first, before we start actually applying the law, it's important that we understand where our various laws come from here in the U.S. So we really have four main sources of law here. I'll just kind of go through these very briefly. Your textbook will go into a little bit more detail, but I'll give you some examples here as well. So statutory law is probably the law you're most familiar with or that you hear about the most. Statutory law is essentially laws that are passed by legislative bodies. So that could be laws passed at the federal level by our Congress. That could be laws passed at the state level. Could be laws passed at the local level. Essentially, we're just looking at laws that are passed by some kind of legislative body. An example of a statutory law, the Americans with Disabilities Act. That's a federal law that was passed by Congress back in the 90s, so it falls under that category of statutory law. We're going to look at a variety of statutory laws this semester, the ADA being one of them, Title IX being another. So we'll get into more detail on those later this semester. Okay, constitutional law. Also probably an area you're familiar with or at least have heard of. These are laws that are embodied in our U.S. federal constitution and individual state constitutions. So these are laws that are inherent and they're coming straight from our Constitution. So at the federal level, of course, we have things like the First Amendment, which guarantees freedom of the press, freedom of religion, freedom of speech. Those are all individual laws that come straight from the Constitution and that are then applied to our everyday life and basically provide U.S. citizens some kind of freedom from governmental action. We're going to look at constitutional law as its own subunit this semester later on, I think after the midterm break. So that'll be a while, but we will look at the First Amendment in particular, examining things like freedom of speech, freedom of religion. We're also going to look at some of the other laws inherent with the Constitution, like equal protection, due process, those sorts of things. Okay, I just want to mention administrative law. We're not going to spend a ton of time on this particular source of law this semester, but it is important for you to be aware of. So administrative law are essentially laws that come from individual agencies in a particular area. So these are basically just specialized bodies that govern a certain area in society. So for example, for us, something we'll look at later this semester is contract law and labor law. So in that area, we have what's called the National Labor Relations Board, which is its own organization that develops law related to contracts, labor law. And so that's an example of administrative law. Again, not something we're going to look at a whole lot, but that's one area we will examine. Okay, last source of law here is common law. So another way to look at common law, or another way you may have heard of it before, is case law. So these laws are essentially coming straight from actual court decisions. So a court is making a decision on a case, and then from that point forward, other cases have to follow that, what we call precedent. Okay, and we're going to define that term here on the next slide. But know that when we talk about common law, we're essentially just talking about case law. So actual court decisions that are occurring that then in turn become common law. Okay, so a little bit more on that here, particularly that term precedent that I mentioned. So you can see here our definition of precedent is a prior court decision that's been established by a higher court that is then in the future regarded as a guide for future cases. Probably the most famous precedent or common law that we have in this country is Roe versus Wade, which was a famous Supreme Court decision that essentially legalized abortion in this country. So ever since that case was heard back in the 70s, that has been the precedent, meaning that any other case regarding a similar issue or question is then led by that precedent. So court decisions are made based on that precedent that exists. In our field, there are also some precedents that dictate law. One that you might be familiar with is the baseball rule, or what historically has been the baseball rule, which essentially for years said that if you got hit by a foul ball when you were attending a baseball game, or any ball, it doesn't have to be foul ball, that MLB or any baseball stadium was covered by what we call an assumption of risk. Okay, so by going to a baseball game, you assume some level of risk that a ball could fly and hit you in the face. So for decades, that assumption of risk precedent was applied to these cases. So if someone got hurt, they tried to sue a team or a player, courts would generally throw those cases out because they knew that this precedent had been established that teams are really protected because of this assumption of risk doctrine. Well, in recent years, we've seen this shift a little bit, and a couple of other cases have come out that have turned the tables a little bit, meaning that this precedent is weakening, that judges are making different decisions now based on the way the game is played today, the rise in injuries caused by these flying balls or bats. So that just shows you that while precedent may exist at some point in time, just like all other areas of the law, it's fluid and changes over time and can evolve over time. So if you want to know a little bit more about that baseball rule, I did upload an article on our ReggieNet page under the bonus content section. So feel free to read into that a little bit more if you're interested. Okay, so we've talked about sources of law. Now I want to talk a little bit about the different types of lawsuits that can be filed here. So generally we have either a criminal lawsuit or a civil lawsuit. So generally it's determined based on the facts of the case, okay? So there's some key differences here that I want to go over, and then we'll talk about a really important element of a lawsuit, which is this concept of burden of proof and how it's different for each. So criminal lawsuit, it's pretty straightforward. If you commit a crime, what the law sees as a crime, you're going to have a criminal lawsuit. So I gave you some examples there of what the court considers to be actual criminal acts. In a criminal lawsuit, what the court is looking to do is determine whether or not the party is guilty or innocent. And you'll see here, when we look at civil lawsuit, that's a little bit different. We're not necessarily trying to determine guilt or innocent in a civil lawsuit, trying to determine whether or not a party has legal responsibility or owes a legal responsibility to the other party. You can see I've given you some examples here for what civil lawsuits are. So civil lawsuits are basically anything that isn't a criminal case, some kind of dispute between two parties. Those parties could be individuals. It could be an individual suing an organization. I'll use the women's U.S. soccer team as an example here of a recent civil lawsuit. So a group of those players have come together to file a civil lawsuit against the U.S. Soccer Federation in a pay dispute that they have. This is a civil lawsuit because it's a dispute about pay inequity or discrimination based on gender. So you can see how that would be a civil lawsuit and not a criminal lawsuit where someone has actually committed a crime. Okay, burden of proof, a couple of things to mention here. Essentially, burden of proof is basically the extent to which whoever the prosecutor or plaintiff is in a case has to go to prove their case. Okay, so as you can see here, that level is much higher in a criminal trial. So in a criminal trial, jury has to be 100% sure of guilt, or what we call beyond a reasonable doubt. There can be zero doubt in their mind that that person is guilty in order to convict. As you can imagine, it's quite difficult to meet that standard. In a civil case, that burden of proof is quite a bit lower. In a civil case, plaintiff only has to prove what we call a preponderance of the evidence that the other side is guilty. So that means essentially they just have to believe, 51% or more that they're more likely to be guilty than not. Again, they don't have to be 100% sure. So as you can imagine, quite a bit easier to prove your case in a civil courtroom than a criminal one. So that's an important thing for us to note as we're thinking about the difference between these two types of lawsuits. Okay, I want to mention real briefly here that we do have a couple different options for people when they go to file a court claim. So there are a couple different levels that cases can be filed in, and you can see here we've got special or administrative courts, which we're really not going to talk about too much in here. The two we're going to focus on are the state level and the federal level. So ultimately, when someone goes to file a lawsuit, they're probably either going to file it at the state level or the federal level. How do we know which level they can file it? Well, a couple things here. First of all, we need to define this term jurisdiction. So when we say jurisdiction, basically all we're talking about is whether or not a court has the authority to hear and decide a case. So a case either has state jurisdiction, federal jurisdiction, or potentially both. It's very important that a plaintiff file their case in the correct jurisdiction. Otherwise, it could be very expensive to pay court fees to get these things readjusted, and also a waste of time. So very important we get that correct jurisdiction the first time around. So first, in order to file your case in your state court system, it's pretty straightforward. If you live in that state or you have some kind of ties in that state, you can file a case at the state level. The level of requirement here is not very high to have your case heard at the state level. There are a lot of state courts. That's not necessarily the case about the federal court system. So in order to have your case heard at the federal level, you have to meet one of these items. So the case either has to involve U.S. Constitution or federal law. So I used the Americans with Disabilities Act as an example earlier. If you were filing a case under the Americans with Disabilities Act, you could certainly file that lawsuit at the federal level. Another requirement here, in order to have your case heard at the federal level, if the dispute involves at least $75,000 or more, you can file a case at the federal level. And then finally, if the two parties are from different states, that case can also be heard at the federal level, but only if one of those requirements is met. Again, not all of those have to be met, just one of them. Okay, here's a visualization of those court systems. I think it's a bit abstract to talk about, but when you see it visually, it's a little bit easier here to understand. So you can see on the right side of the screen, I have the state court system. So you can see that in order to initially get into that system, you'd have to have your case heard at what we call trial court level. If you were to appeal the decision in that case, it would go up to what we call the appellate court system. Most states have an appellate court system. If you were to appeal a decision up from there, it would go to the state Supreme Court. And then if you wanted to appeal it from there, it would go all the way up to the Supreme Court at the federal level. So you can see 3 levels there prior to getting to the Supreme Court on the state side. On the federal side, we have 94 of those trial or district courts throughout the country. So that's the initial level there for that trial case. And then there's only one appeals level at the federal level, only 13 circuit courts across the country. So you can see why we can't take quite as many federal cases. There just aren't as many courts. And then finally, if you were to appeal at the appeals level, you'd go up to the Supreme Court of the United States. So that just gives you a little bit of a visualization of those two court systems. Okay. Real quick, I just wanted to do a quick refresher on how the Supreme Court works. You might be familiar with this from your civics classes. You might just be, really in tune with what's happening in the news, and then you'd probably be aware of some of this as well. But real quick, I just wanted to give you a little bit of trivia here on how the Supreme Court works. There are 9 justices at any point in time. As you can imagine, it's important that there's an odd number of justices because they're deciding some really crucial cases, and the last thing you want is a tie, right? So we have to have that odd number to avoid that. How are justices appointed? Well, they're appointed in this process where they're nominated by whoever the president is at the time, and then the Senate has to vote to confirm that candidate. If you paid attention at all to the news in the last year, you know there was a pretty hotly contested nomination process of Judge Kavanaugh, the newest Supreme Court member. So you got to see that process play out in real time. Finally, how long is the term of a justice? Believe it or not, it is a lifelong term. So when someone is appointed to the Supreme Court, in theory, they are on it for life. Now, oftentimes they will retire when they decide they want to, but that could be, you know, in their 80s or in some cases their 90s. So when we do appoint a justice to the Supreme Court, it's a pretty big deal because that person is probably in their 40s, 50s, and they're going to be there a long time, making really important decisions about our legal system. Okay, a couple other things here about the Supreme Court before we move on. A couple other legal terms for you to be aware of. In order to have your case heard by the Supreme Court, you have to file a written application, which is known as a writ of certiorari. It's a Latin term. You're going to hear a lot of Latin terms this semester. Our legal system has a lot of Latin terminology. So you have to file this written application, basically explaining why you want the court to hear your case. In order to hear a case, 4 of the 9 justices have to vote to hear the case. The Supreme Court, as you can imagine here, receives a ton of these applications a year. You can see on average there are about 10,000 different writs are applied each year. But in reality, they typically only hear about 10% of that. In some cases, not even that many. It varies every year. So your odds of having your case heard by the Supreme Court are pretty slim. As you can imagine, there's a lot of high-level media scrutiny on these Supreme Court cases because they choose so few and because they do fall at the top of that food chain, right? So basically, their word creates legal precedent and creates precedent that has huge implications on our legal system for decades, as you saw with the example of Roe v. Wade. So very important decisions that they're making that impact a lot of us. I gave you a couple examples there on the slide of some recent decisions they made. You might remember a few years back they made the decision about legalizing gay marriage, which has certainly had huge implications across the country for people seeking to marry same-sex partners and just providing more rights for those individuals. A recent sport-related case, which I think is relevant to us, is that the Supreme Court recently made a decision about sports betting that basically gave states the right to decide whether or not they wanted to legalize sports gambling. As you can imagine, that's a pretty big game changer for a lot of states looking to generate some revenue. Obviously impacts those working in the sport industry as well. So those are just a couple of examples. I always like to keep an eye on what the Supreme Court cases are being heard every year. Certainly, if you follow the news, you're bound to hear about them. Okay, so far we've been talking about these common pathways for a lawsuit in the various court systems here in the U.S. But I always think it's important to note that there are options outside of our court system when it comes to a dispute and resolving that dispute. We call that alternative dispute resolution. So basically, these are alternative methods for resolving legal conflict that don't allow an actual trial. So basically, you're deciding to keep your case out of the legal system and into someone else's hands, either an arbitrator or a mediator. So real quick, definitions on these. An arbitrator or arbitration essentially exists when two parties basically make their case to an independent arbitrator, and then that arbitrator makes a call. Basically, they make a decision, and that decision is binding. You often see an arbitrator used in some of the leagues when they have salary disputes with players. Arbitrator is brought in to be an independent decision maker, see both sides, and then make a binding decision. A mediator, on the other hand, is a little bit different. So with a mediator, you're also coming to the table, both sides, and then kind of sharing their side and what they're looking to gain. But instead of making a binding decision like an arbitrator, a mediator is there to really work with both parties and help them find some common ground. Oftentimes you'll see sport or recreation organizations bring in a mediator, if they're hoping to work with that party long term, right? They want to keep that relationship positive, so they may look to bring in a mediator to help them come to some kind of common ground. Some pros and cons of using ADR over the traditional court system. So some pros, typically this is faster than moving through our legal system. As you'll see in a case study we're going to look at next Monday, our court system can take a very long time to decide a case, particularly if it involves appeals. We're talking years in some cases. So ADR can often be quicker, can often be resolved within a year's time. So that's certainly a pro. Can be more affordable depending on the situation. You don't have all those court fees that you have otherwise. Another big pro, especially for larger organizations like a sports league, for instance, is that you can keep your dirty laundry, per se, private, right? If it's in court, then it's in the public. But if you can hire a private arbitrator or mediator, that information is going to stay private. So, for example, I believe Colin Kaepernick worked with the NFL over this past year to come to some kind of settlement agreement. Obviously, they wanted to keep that information private. So, in this case, ADR probably made a little bit more sense. Anytime you're trying to avoid negative PR attention, ADR is probably the better route to go. Some cons, certainly one con is that we really don't have the appeal system you have in our court system. So if you go this route and you have an arbitrator come in to make a decision, that's the decision. There's really no alternative route from there. You kind of have to live with that decision. You could also say that a con is that there's an unfair advantage for the people with power in these situations. So whoever is hiring the arbitrator or mediator, even though they're meant to be independent, in some cases, they are still working for that organization. So if you've got someone who's unethical, they may be more likely to side with the party that hired them than the party on the other side. So there are a couple of pros and cons when it comes to ADR. Again, I think it's just important for you to realize that there are other options out there outside of our court system, although we'll focus generally on court cases this semester. Okay, so we've talked a little bit about the structure of our court system and kind of where the laws come from. Now I want to switch gears and talk a little bit about the trial process itself. So we're going to actually go through the steps of a trial in a minute. But I thought we'd talk real quick about kind of where this right to trial comes from. And if you're not familiar, it does come from our Constitution, so our constitutional law. In particular, it comes from the Sixth Amendment, which basically provides every citizen a right to a speedy and public trial. So the idea is if you are accused of doing something, we don't just lock you up and throw away the key, right? This country was founded on the idea that everyone deserves to tell their story. Everyone deserves to have an opportunity in court and be represented by a legal counsel. So that just gives you a little bit of background about where this right comes from. It's not just something we made up. It's actually in our Constitution. Okay, real quick. If you're like me, you probably watched a lot of true crime, a lot of legal shows over your life. So I think we all have maybe a little bit of a skewed view as to what a trial process actually is and the purpose or function of a trial. So I thought we'd look real quick at some of the core functions of the trial process. So really, the function of a trial process here in the U.S. is one, determine the facts of the case. So put everything out there. What are the facts of this case? Let's bring in both sides to tell their story. Second function is to actually decide which rules of law are going to be applied to that particular case. Oh, sorry, a little pop-up there. So we actually have to decide which rules of law are going to be applied. So if it's a federal law or statutory law, we need to know that. And then finally, the main function of a trial is really to interpret and administer whichever laws we believe need to be applied to that case. This is an important one. I think oftentimes we think of trial court actually making law, but they don't make laws, they interpret them. So the laws are created by legislative bodies, they're inherent in our Constitution, but generally the function of a trial process is to interpret those existing laws. Certainly, sometimes case law or precedent is established through a court decision, but generally it's the job of the trial process to interpret and administer existing law. Okay, so I want to talk now a little bit about who the actual parties or players are in the various lawsuits we've been talking about, because this is important terminology that you're going to hear about all semester. So I want to make sure we all have the same understanding of what we're talking about here. So civil case, we said these are disputes between individuals or disputes between an individual and an organization. So in a civil case, the party that's actually bringing the suit is known as the plaintiff. So you can see here I've given you an example of an actual complaint. This is the U.S. Women's Soccer complaint against the U.S. Soccer Federation. So you can see here all of those players are listed as plaintiffs. So they're the party bringing the suit. And then the defendant is the party being tried. So you can see here listed as defendant is the U.S. Soccer Federation. So again, civil case, plaintiff is the party bringing the suit, defendant is the party being tried. Okay, criminal case, it's a little bit different. You'll notice some crossover here with the defendant, but there's a different terminology for the party bringing the case. So in a criminal case, it's not a plaintiff that's bringing the case, it's what we call a prosecutor. So here it's the legal party responsible for presenting the case against an individual accused of breaking the law. So in a criminal case, you won't see a name listed as the plaintiff. Typically what you'll see is whatever state that party resides in. So in the Jerry Sandusky trial from several years back, he was the Penn State coach accused of molesting some of the young boys within their program. In that particular case, he was being accused of a crime. So instead of those individual plaintiffs filing a lawsuit against him, although some of them did in a civil ground, the state of Pennsylvania brought a case on behalf of those individuals. So that's what we're referring to when we refer to the prosecutor in a criminal case. So if you were to read the complaint in this particular trial, it likely said state of Pennsylvania versus Jerry Sandusky. So in this case, you see defendant is the same in both civil and criminal cases. So the party being tried is still going to be the defendant. It's just going to be that party that's bringing the case that's different. Okay, let's see here. I want to talk about the various steps in the trial process. Now, your book goes into a little bit more detail on this topic, so I'm not going to spend too much time on it, but I do want to highlight a few things here. Okay, first step in the trial process is what we call pleading. This is kind of the step of a trial process that all the paperwork is filed. It's kind of a boring step, but in order for a case to move forward, a lot of paperwork is required. So here in the pleading, you have a couple of different sub-steps. That first is a complaint. So in order for a trial to start, you actually have to have someone file initial paperwork claiming what their complaint is. Right? So basically just a form explaining why they're suing someone else. From there, a summons is delivered to the defendant. So basically they're given legal documentation explaining why they're being sued and by who. From there, defendant does have an opportunity to respond through what we call the answer phase. So here they get a chance to either plead guilty, or maybe they say they want to fight the claim, or in some cases actually file a counterclaim against the person bringing the suit. So a couple different options there. But in general, that's step one, pleading. It's where we're getting all the paperwork knocked out. Okay, next step, step two, which is called the discovery phase. This is basically where both sides are doing all their homework, right? They're collecting all the information they might need to bring this case to court. So that could depend, varies depending on the case, right? So someone might be gathering video footage of an incident in order to show that in the actual trial. Someone might be trying to gather medical evidence, right? Medical records. These are some examples of the information that might be gathered during that discovery process. I'm going to let you guys do a little bit more digging on these definitions in your book, deposition versus interrogatory. But basically what you need to know is the deposition is going to occur in the courtroom. So a witness actually comes there and is recorded, they're questioned. An interrogatory is a little bit less invasive, might involve them filling out some kind of form or questionnaire outside of court. But again, your textbook goes into a little bit more detail there. Step three, we have what are called pretrial motions. Keep in mind, we're 3 steps into the trial process here and we haven't even started a trial, right? So a lot of steps coming before an actual trial. Basically here, both sides, and what I should say is both lawyers for each side, have the opportunity to basically get the case to stop where it's at. So they might file a motion to dismiss, saying, hey, we want this case thrown out. We don't think that the plaintiff has enough evidence to move forward. They might also want to file what we call motion for summary judgment. That just means, hey, we think you, as the judge, you have enough information now, you can determine this case today. We don't need to go to trial. So there are a number of pretrial motions beyond these two. These are just a couple of examples. But basically, this is the phase where the lawyers work with the judge and attempt to stop the trial where it's at and keep it from actually going to trial. Okay, step 4 is jury selection. This is a process where essentially both sides get the opportunity to select the members of a jury. You can see a definition there for a jury if you're not familiar. Typically what happens in these jury selection process is an interview process. So if you've been called for jury duty, you're probably familiar with this already. If you haven't been, this interview process is known as what we call voir dire. Another Latin term, basically just means interview process. So potential jurors will be questioned. They might fill out a questionnaire. If they make it past that phase, they might actually be questioned by the lawyers on both sides. It's a long, drawn-out process which ultimately ends with either side getting to say yes or no to a potential juror, with the goal, obviously, to make it a fair trial so that you have people that are going to make a decision not based on any kind of background, familiarity, or history that might impact their decision-making process. Important to note here that with civil cases, the plaintiff has the option. They can either have a jury trial, which is the traditional form, or they can have a non-jury trial, which is referred to as a bench trial. So basically they can decide, hey, I don't want a jury in here, I just want the judge making the ultimate decision. Obviously it's going to depend on the individual plaintiff and what their case is, but that is an option. Okay, so we finally made it to the trial, step 5. So again, anytime we see a trial on TV or in the movies, generally we're starting here, but really, in reality, there are a lot of steps that come before actually getting to the trial. And as we'll talk about in a little bit, a lot of cases don't even get to this stage, and as you read in your reading. So the trial itself, listed here, sort of the steps of the trial. I'm not going to go into a ton of detail here. I do just want to mention that there are a couple of key terms here that we should be familiar with, and I've highlighted those. So testimony and exhibits. So these are things that can happen during the presentation of evidence. So testimony is generally when you actually call up a witness and ask for their testimony, ask for them to tell their story, provide information to the court. Exhibits are actual evidence. So if a lawyer brings an actual piece of evidence they want to show, whether that's video footage, a medical record, whatever it might be, they would actually bring that in as an exhibit. So that's just the difference between those two there. In testimony, you can call either an expert witness or a fact witness. So this one's important for us to be familiar with. So an expert witness is generally someone who has a particular expertise on a topic. So let's say that we've got a trial involving a school and an incident that occurred in a PE class. An expert witness in this case might be someone who has, a long career as a physical education teacher, right? They could be considered an expert witness. They likely have nothing to do with the school, with this community, but they've got experience in the field that could be helpful for that courtroom to hear, for that jury to hear. On the other side of that, you can call a fact witness. So fact witness is someone who was actually there, who has firsthand information or an account of something that happened surrounding the trial or the incident. So fact witness doesn't necessarily have to have an expertise, but they have to have an awareness of what occurred because they saw it firsthand. So that just gives you an idea of the difference between an expert witness and a fact witness. We'll talk a little bit more about that when we get into our case study next Monday. Finally, there you see just sort of a breakdown of the trial itself. Again, I'm not going to go to too much detail about that. So I think you probably have seen that play out in some kind of media at some point in your life. Okay, before we talk about judgment here, I do want to mention that per your reading, I think the estimate is that 90 cases don't actually make it to that trial process. So you can imagine, we're going to talk here in a minute about the settlement element of the trial process. But that's pretty crazy to think about. We often think of any case that's filed as going to trial, but the reality is most cases don't get to that courtroom, don't get to that trial process. And there are various reasons for why, and we'll talk a little bit more about that here on the next few slides. Step 6 is the judgment. So this is essentially where the jury is provided instructions. So they might be given instructions about how they are to decide that case, which laws they're to base it on. That jury will then deliberate for some time. Could be a matter of minutes, hours, days. Really depends on the trial and the jury makeup. And then finally, a verdict is delivered. Okay. I want to talk a little bit about the appeals process because I think generally there's some confusion here with students. So important to note that an appeal is not a retrial. So not necessarily a retrial. When we think of appeals, we think someone's not happy with the decision of their trial, so they want a do-over. And that's just not what the appeals process is built for. You can see the main function here of an appellate court is to review what has already happened at that initial court level and basically decide whether any legal errors have occurred. So if a legal error has occurred in that initial trial, then various decisions could be made. And you can see there are basically 3 different options here. A decision can be affirmed, which means that the judge agrees with that decision of the lower court. And basically nothing changes, right? They affirm what was decided, moving on. Another option, if the judge decides that they disagree with that decision and that there's clear evidence that legal statute wasn't followed, then they have the ability to reverse that decision. Keep in mind, it is very rare for a court to reverse a case or a trial decision. I think it's less than 10% of appeal cases are actually reversed by a judge. So this is a pretty rare occurrence. The last option here is that a court can remand a case. And when we say remand, basically what that means is they're sending the case back down to the lower court level for a retrial. So a retrial can occur, but the judge at the appeals level has to make that decision. They have to find that some kind of legal error occurred, either in the jury process or the way the law was applied. There are a number of things that could impact that that could create a legal error, but they have to be able to find one in order to actually send that case back down to the trial court level. Okay, we mentioned earlier that very few cases actually make it to the trial process. So what often happens instead is what we call a settlement. So basically the parties come together before an actual trial and resolve the disagreement. Now in a civil case, that typically means some kind of monetary damages are exchanged. In a civil trial, what the plaintiff is seeking is really just to be put back into the financial position that they were in prior to the dispute. Okay, so in a civil settlement, basically they're looking for some kind of monetary damages. Keep in mind, the civil lawsuit system is not meant to be like a get-rich scheme, right? Civil courts are looking to put that person back into the financial position they were prior to any kind of dispute. Criminal cases, on the other hand, are a little bit different in the settlement process. So a settlement in a criminal case might mean that the defendant agrees to serve X number of years in jail. Or they might, if it's less severe, they might agree to some kind of community service hours. So instead of monetary damages here in a criminal case, typically they're agreeing to serve some kind of time. A couple of examples here of prominent settlements. You might remember a couple of years ago, Jameis Winston was accused of rape while he was at Florida State. That plaintiff ended up suing the university because they failed to properly manage that complaint that she had made from a Title IX office perspective. And they ultimately ended up having to pay her, I believe it was like $800,000 in the settlement. Again, that was decided before actually going to court. Similarly, more recently, you probably have followed this Michigan State case with the gymnastics trainer, Larry Nassir, who was accused of assaulting many women at the university. And they have recently paid out a $500 million settlement to those plaintiffs. So you can see that oftentimes in these cases, settlements end up being paid out by the organization itself. In these cases, sport organization, athletic department through these universities. But important to keep in mind that this is honestly the way most of the cases that you see will end up, some kind of settlement. And again, the reasons vary, but oftentimes people are looking to avoid a trial. They're looking to avoid a trial because it's costly, right? You got to pay a lawyer, you got to pay court fees, it could be expensive. You're trying to avoid time. So if you're involved in a court case, it could take years of your life. And so people want to avoid that, right? They want to just get on with their lives. So they might want to settle because of that. For a lot of sport and recreation organizations, again, they're trying to avoid bad PR. So instead of having the case play out for years in the media, it may be better to make that settlement and get it to go away.